Both parties should deserve equal rights, and it must be a mutual agreement for the child to receive records from the birth parent. According to Shadolsky 2000, Hunsaker, the father of 5 adopted children, said he opposed the law because it could expose women to unwanted encounters. I rejoice in reunions, but I strongly believe that they should be by mutual consent, he said. Birth parents have a certain date to block the access for children to have original birth certificates, but there are no stricter standards. The new law enables the birth parent to have the option to disclose their information, but after 5 years, the adoptee can re-ask the birth parent again. Shadolsky 2000. Megan Bagatis from Forest Park stated, I am a birth mother whose son searched and found me 6 years ago. I was completely surprised and unprepared for this event. Having surprise visits to the adoptive parent's house is extremely unethical because the parent will not be prepared, and it may also result in traumatizing experiences for both parties, when the experience can be a positive one, but mainly if both parties have given consent. The status quo does not need to change. Everything has been running smoothly and fairly thus far, and a court order should still be implemented. It is important for the court order to continue being implemented because having access to birth certificates should remain as confidential as possible until needed under certain circumstances. If this does not occur, both parties could end up being heard in the end. The plan has been in effect for almost a month now and has flaws to the system, which needs immediate attention. It is crucial for both parties to have mutual consent, and a child should be able to receive birth records, but only if necessary for the person involved. Therefore, court orders should still be implemented to ensure equality for both parties. It is extremely essential for the person to have the ability to receive their medical records, but the birth parent should have the option of disclosing their personal information. There is no reason for this law because the people who wanted it had the opportunity to obtain it, but now it has become more limited for those who need their birth records. Also, Shadolsky 2000 mentions that the Christian Coalition argued that exposing women to potential unwanted reunions would lead to more abortions. Due to the new law, more adoptions that would have been closed from before implementation would now be open. This may cause birth mothers to reevaluate their pregnancies, which may result in more unfortunate abortions. Yes, having access to birth records is pivotal, but disclosing information that the birth parent does not want to disclose is unethical. The new law enables the birth parent to have the option to disclose their information, but after 5 years, the adoptee can re-ask the birth parent again. Advocates of the bill are hoping the birth parents will opt to fill out their medical history, so their children can receive vital information, Mitchell said. If the parents do ask for anonymity, the adoptee can go to the court 5 years from the date and initiate a search for updated medical information free of charge, Garcia 2010. The adoptees should have access to medical history and birth certificate, but not the name and address of the birth parent. There can be detrimental effects if the parent or child is not what the person envisioned. For example, if the birth parent is not as engaged as the child hoped, that may skew the child's opinion on the parent and ultimately leave the child traumatized or extremely saddened by the event. To know one's genealogy and all that it entails is to know essential information about oneself. To know one's birth family is to know oneself in a way that includes and transcends the physical. A birth certificate is the first legal document a person receives in life, and those seeking to change laws argue that to deny a group of individuals access to that document is a violation of their rights as citizens. When you grow up, you have certain rights under the law to certain documents, said Damsel Plum, co-founder of a national adoptee rights organization called Bastard Nation. We approach this as a civil rights issue. Accessing this information can be seen as a violation of birth parents' rights to remain anonymous and invasion of their privacy. Frank Hussenker, an attorney representing 6 anonymous birth mothers who sued to block the law, he asked that the Oregon Supreme Court to review its earlier decision that the new adoption law did not violate the state's constitution. On Monday, the court agreed to consider Hunsaker's arguments and bear the new regulations from taking effect until at least May 2nd, the date Hunsaker's petition is due. Hunsaker, the father of 5 adopted children, said he opposed the law because it could expose women to unwanted encounters. I rejoice in reunions, but I strongly believe that they should be by mutual consent, he said. According to Shadolsky, new laws supporting adoptees seeking their birth records could deny women the anonymity they want. Many of these birth mothers choose to remain anonymous through closed adoptions, and making the birth records available to all adoptees would provide them with sensitive information such as the birth mother's and sometimes father's names as well as their last known address. This may be a potentially crippling invasion of privacy and a threat to the lives that they have built since giving up their children. It is extremely essential for the birth parents and children to have equal rights, and in the affirmative, the idea of the rights the children seem to have more of an emphasis. As mentioned in Shadolsky 2000, Cindy, a mother who gave up her child for adoption for a valid reason, states, "All we are asking for is the same everybody else in America has. I want my privacy. I want control to the release of my identity." Again, both parties should have equality over decisions being made, not simply the child. The affirmative states that 88.5% of birth parents supported the adoptees gaining access to this information. But where does that leave the other 11.5%? These women have a right to their privacy and to keep their adoptions closed. It should not be solely in the hands of the adoptees whether or not they get in contact with birth mothers. The decision should be mutual. It is unjust for one person to have more say in the situation than the other. That way, hopefully, both the birth parents and child can have a healthier encounter if they both decide to go that route. As mentioned in your plan by Women's 2010, the Child Welfare Information Gateway last updated on June 29. More than half of the states and territories in the United States still require a court order before releasing original birth certificates. They also state that a survey of 130 birth parents resulted in the parents agreeing to give up the information and have their children locate them at the time of adulthood. But what about all of the other parents that gave up their children? How do they feel about this issue? We cannot be sure that all birth parents of adopted children want to be contacted. We cannot provide protection to all of the birth parents that do not wish to be contacted. All we can do is ensure that the parents know about their new laws and have the option to stop all contact if they desire. Adoptees have a right to know their medical histories, but there is no reason for unwanted contact with their birth parents, because knowing one's medical history is more of a priority than simply having access to birth certificates.
Okay. You mentioned that the Christian Coalition argued that exposing women to potential unwanted reunions would lead to more abortions. How would this affect the number of women choosing abortion?
When a woman is pregnant and considering adoption, she may become too nervous to give up the baby because of the new bill. Having that specific encounter at a later date may result in bad memories being dredged up, and if the mother does not want that, she may consider her other options, the other option being abortion. There should never be more reasons for abortion to occur. It is a devastating issue and needs to be lessened as much as possible.
You also said that the adoptee can ask the birth parent for permission for a second time after a 5-year waiting period. If the birth parent still does not wish to be contacted, can't they just decline again?
Yes, they can decline. However, the mere act of the child seeking the parent could cause as much devastation as the child re-entering the parent's life. Frank Hunsaker, the father of 5 adopted children, said, he opposed the law because it could expose women to unwanted encounters. He said, I rejoice in reunions, but I strongly believe that they should be by mutual consent.
You say this is an issue about the civil rights of the parent, but what about the rights of the child who was given up for adoption? The parents relinquish their rights for anonymity when they bear the child.
Well, the parents still have rights to withhold their personal information if they do not wish to be contacted by the child. Yes, the child has a right to know their history and genealogy, but the parents have the right to privacy as well. Accessing this information could be seen as a violation of birth parents' rights to remain anonymous and an invasion of their privacy.
You mentioned medical history as one of the most important things to have access to, but what about their birth certificate? You also mentioned how this was the first thing that the children get when they are born, which tells them where they come from.
As mentioned before, many of these birth mothers choose to remain anonymous through closed adoptions, and making the birth records available to all adoptees would provide them with sensitive information such as the birth mother's and sometimes father's names, as well as their last names and addresses. I'm not saying that it's not important, but I believe that a person's health should be the priority over knowing the names and addresses of their birth parents.
You bring up the affirmative study that states 88.5% of birth parents supported the adoptees gaining access to this information. Do you think that 11.5% is enough to counteract and cause this bill to not be passed?
We believe that if there are any women who do not wish to be contacted, they should have the means to express this desire. Why should their free will be taken away because others are okay with being contacted? If they do not wish to receive contact by their children, they should be able to have the option to decline all of the advances.
First of all, I'd like to reinstate that according to a 1991 study published in the American Journal of Orthopsychiatry found that a substantial majority of birth mothers, 88.5%, supported adult adoptees' access to identifying information regarding their birth parents. With such a large percentage of birth mothers added to the even larger percentage of adoptees in favor of this bill, it is clear that this will overall benefit both birth parents and those who were adopted. We do agree that with the negative that it is unethical to disclose personal information about birth parents that these individuals do not want exposed. However, as the negative also states, a birth certificate is the first legal document a person receives in life, and those seeking to change laws argue that to deny a group of individuals access to that document is a violation of their rights as citizens. When you grow up, you have certain rights under the law to certain documents, said Damsel Plum, co-founder of a national adoptee rights organization called Bastard Nation. We approach this as a civil rights issue. The affirmative approaches this as a civil rights issue as well and believes that it is the inherent right of any individual to access their birth certificate. The negative argues that this law will deny anonymity to women who give their children up for adoption. It is true that the birth mother will not remain anonymous after the adoptee reaches adulthood, but these adoptees live their entire youth life not knowing where they are from, who their parents are, and important medical history that is usually knowledge we are all allowed access to. Just because a mother chose to give up their child for adoption does not mean that the child does not have the inherent birth rights that we all have to accessing our birth certificates and medical history. In respect to the invasion of privacy of birth mothers, founder of this bill, Pat Quinn, states, "This new law provides adopted adults with the tools they need to obtain and review crucial personal information and background," said Governor Quinn. At the same time, this law respects all the parties involved in the adoption process. Birth parents are allowed to deny access to certain personal information, but at the same time must give up some information to provide the adoptees with vital knowledge about their personal history. Senator Wilhelmi states, "This legislation restores the basic right of adult adoptees to know who they are and where they came from, including their family and medical history. This is a balanced and fair measure that respects all parties involved in the adoption process." Not to mention, a number of medical and child advocacy groups support the legislation, including, but not limited to, Illinois Psychiatric Society, American Adoption Congress, Child Care Association of Illinois, Voices for Children, Department of Public Health, Department of Children and Family Services, National Association of Social Workers of Illinois, Baby Fold in Bloomington, Illinois, and the list goes on. These groups are extremely credible on adoption-related issues and all agree that this law is in favor of those adults who are adopted as children and have access to these legal and vital documents. In addition to all the support, there is a physical evidence that this law does more good than harm. According to an article published by Children's Voice in 2010, as more states change their laws and the dire predictions of those who had favored the status quo fail to materialize. Pertman says those opponents of change have to narrow their arguments. We have changed these laws, we've changed it in a bunch of states, and we haven't seen negative consequences, so why not change it? Also, in Williams' 2010, Feigenholz notes that most of it, if not all, of the changes to birth certificate access laws have come from members of third-party birth parents, adoptive parents, or adult adoptees. Pertman thinks that this is not surprising. With any legislation, it's the people who are most directly affected who become the most passionate about making it happen. People who are adversely affected stand up and say, "We've had enough." If recent state legislation is a fair barometer, there is a wave of people standing up for this issue across the nation. Moreover, Pertman says now is the time. It's critically important that the momentum behind changing these laws accelerate. He affirms, explaining that the people who would benefit from these changing laws are the most aging. They're now getting older without getting what they really, really want, which is to know what happened to the lives they've created. Overwhelmingly, that's what they want. If we don't change these laws pretty soon, they're not going to get that. Of course, we cannot ensure all birth parents, adoptive parents, and adult adoptees will benefit from this bill, but it is clear that the large majority will. The affirmative is fighting for the inherent rights of each individual, adopted or not. It is a right from birth to receive your birth certificate that is not limited to only those